of all, I would like to extend my sincere gratitude to the LJRF voice, especially the editor-in-chief Raniel Niada and advocate Advocate Arya and every people who are working for the law LJRF voice. And I also extend my sincere gratitude to the Nidu and also Shivaranjani. And I also extend my sincere gratitude to my co-speaker, Lowell Mansur, an assistant professor of Government Law College, Calicut. And thank you very much. So this case is a very important case because of so many reasons. And I think you all gone through the judgment of Hijab judgment, the split verdict of the Honorable Supreme Court Judges Justice Hemant Gupta and Justice Dulia. This judgment has a lot of constitutional importance because of so many reasons. Because Justice Hemant Gupta, he said he in his judgment he mentioned the fact that hijab ban is justified and declared hijab ban is constitutional. And Justice Sudhamshu Dhulia, who delivered hijab, he delivered the judgment that hijab ban is unconstitutional because it violates many of the fundamental rights of petitioners. So, as you know that what is constitution? Constitution is nothing but what the judges say. So, in this case, there was no same voice from both the judges, and if there is no same voice from both the judges, then there was a conflict in the mind of the people that who is right and who is wrong. And so you know that the constitution, what actually Justice Hemant Gupta, the important question is which is in front of my mind and in front of those who are participated in this program is whether Justice Hemant Gupta is right or Justice Dhulia is right. So therefore, we have a constitutional right to. Why we have a constitutional right to discuss this issue in the light of the fundamental rights guaranteed under Article 19 and Article 21 of the Constitution? That is also a very important question. So the question is whether we have a right to discuss this important judgment in a public forum is a very important question. So for that, I just this was the case reported in Hindu daily that when that verdict was delivered. So in this particular case, the Hindu reported that it was this is the news reported in the front page of Hindu that the Supreme Court delivered a split verdict on Karnataka hijab ban. And therefore, the question is whether we can discuss, whether we have any right to discuss this judgment in a public forum. So if it is permissible, then under what ground it is permissible? So this is permissible because of two reasons. Because I think you can see two important world-renowned legal scholars, and so we could understand that the first one is Thomas Paine. That is Thomas Paine, as you know, that he is the founding father of American Constitution. And in his classical book, Right of Man, which is available online, when you Google Right of Man, you will get that Right of Man online without any cost. In that book, he said that a constitution is not an act of the government, but of a people constituting a government, and the government without a constitution is power without right. And a constitution is nothing antecedent to the government, and the government is only the creature of the constitution. So that is a very important statement of legendary Thomas Paine, one of the founding fathers of American Constitution, which is mentioned in his book, Right of Man. So the government, what is the legal status of a government, including the Supreme Court of India, including the Parliament, and including the executive, is the creature of the Constitution. So Constitution is the people's document. So what was the opinion mentioned by Dr. Ambedkar? What was the statement of Ambedkar, the founding father of Indian Constitution? He mentioned the fact that Constitution is not a merely lawyer's document. It is a vehicle of life. And its spirit is always the spirit of age. It means it is the spirit of the age, 1.5 billion people. So from these statement of these legal scholars, we have a right to discuss this judgment in a public forum, because every citizen in a democracy have a right to discuss the functioning of its government. And it is a right guaranteed by their respective constitution. So, so in this case, there are the important questions in this particular case was the nature of the constitution. What is actually the nature of the constitution? Second one is what are the different rights of the citizen? And third one is the power of the state to impose restriction over the right of citizen. These are the most important questions discussed in this particular case. In the judgment of the Karnataka High Court as well as the judgment of the Honorable Supreme Court of India. So, in the first important question that was discussed in the Karnataka judgment as well as in the judgment of the Honorable Supreme Court was what is the nature of secular constitution? So, as you know that Indian constitution is secular in its nature, and the secularism is a basic structure of Indian constitution, which was so held in the Keshavananda Bharati case in 1973. And also in the Indira Nehru Gandhi versus Narayan, it was repeated. This mentioned that the secularism is actually the basic structure of Indian constitution. And in the 42nd constitutional amendment in 1976, it was incorporated in the preamble of the constitution. And after that, there are a number of judgments, including the S.R. Bombay versus Union of India, and so many other judgments. The Honorable Supreme Court held that the secularism is actually the basic structure of Indian Constitution. If it is a basic structure of Indian Constitution, then the constitutional position is that it cannot be altered by the Parliament by using its amending power, and it cannot be destroyed by the court by using its power of interpretation. So that is what the position of secularism. But in this case, there was a question: what kind of secularism is actually there in the Indian Constitution? So in the judgment of the Supreme Court, it was mentioned the fact that Justice Gupta mentioned the fact that this is the Western concept of secularism is there in the Constitution. But at the same time, I am mentioning two incidents in the history. The two incidents in the history that I consider relevant in order to explain the secular character of the Constitution. The first one was that you were watching the picture in the PPT, that it was an incident which was happened in 1893, September 11. That Swami Vivekananda's speech in the Parliament of Religion, Chicago, United States of America, where Vivekananda represented his motherland, India. That is, he explained our culture. He actually not explained our religion, Hindu religion, but he clearly explained our culture. So, what is our culture? He did not explain the greatness of Hinduism, but he did explain the way of life of Indians, because Hinduism is nothing but only a way of life. He explained the greatness of our nation, our culture, a culture which is very ancient, a culture that promotes tolerance, a culture that promotes universal acceptance, a culture that accepts greatness of all religions. This culture was reflected in our constitution from its beginning, especially in Article 25 of Indian Constitution, by promoting every person and by permitting every persons to profess, practice, and propagate any religion of his choice. So, this is actually a culture which is inherently there in the Constitution. So, this is another important incident that that our secular values of the constitution, all values of the constitution, including the secular values of Indian constitutions, came from the freedom struggle of the values which are there, which were there in the leaders of the freedom struggle, including Mahatma Gandhi, which includes a lot of important virtues and values: sarva samabhavana, panthanirapekshita, satyameva jayate, yado dharmas tado jeha, non-violence, purna swaraj, sarvodaya, antyodaya. These are the values which are inculcated from the freedom struggle, which are essentially part of our constitution, and it is derived from our culture. So this was reflected in the Constitution Assembly debates. Then after that, it was part of Indian Constitution. So our basic values of the constitutions, including the secular values, are inculcated from these Indian culture and also the freedom struggles of India. So there was a statement where when Swami Vivekananda was in America, a lady asked Swami Vivekananda that you can't wear a proper clothes to look like a gentleman. So Swami Vivekananda smiled and said that he said that in your culture, a tailor makes a gentleman, but in our culture, character makes a gentleman. So like this, because as you know that this is actually the roundtable conference where the Gandhi was participated in two roundtable conference in 1930 and 1931. See his dress code, because in our culture, in the Western culture, actually the tailor makes a gentleman, but in our culture, the character makes a gentleman. So because he was always in a naked form, he was when he participated in the roundtable conference, and he was almost in a naked man when he participated both the roundtable conference, because in our culture, dress code is not a matter, but rights and freedoms. And we are trying to create a best society in the world, inculcated in our constitution. This is actually the positive secular idea of Indian constitution. So the constitution in a secular form is more inclusive, more tolerant, and that is what the positive secularism means. So you can see a slide where you know that this person is a famous man and he is a chief minister of one of the largest state in India, Uttar Pradesh. From his dress code, it is clear that he is a Hindu monk. When you look into the dress code of a monk of Sri Ramakrishna order and Bellur Mutt, and when you look into the dress code of Adityanath, you will never find no differences. For example, this is a picture which available online where Adityanath is inaugurating a function of Sri Ramakrishna Mud mission, where you cannot find out the monk of Sri Ramakrishna order or Adityanath on the base of his dress. So he is actually the executive head of the Uttar Pradesh, and the constitution does not prevent him to entering into his office because of this dress code. Because the constitution is more inclusive document, which promotes positive secularism, which is reflected in Article 25 of the Constitution. That because the positive secularism promote inclusiveness and tolerance, which was the culture of our nation. And so this is what is actually when you look into consider the positive secularism is concerned. When you try to understand positive secularism is concerned, this is what the positive secularism means. Because the constitution is the most tolerant document, it is the most compassionate document. It is actually a book which promote inclusiveness, harmony, and common brotherhood. Constitution didn't reject any religion from our motherland. but Constitution respect all religions and provide adequate freedom to all religions, because this country historically, when you analyze, was a religious country. This country was a motherland of four major religions in the world: Hinduism, Buddhism, Jainism, and Sikhism. And we wholeheartedly welcome the Christianity and Islam. That is the history and the culture of this country. So when you are seeing another important picture, which is available in online, this is not a religious ceremony of a temple where our prime minister is participated. It is a Bhumi Puja of our new parliamentary building. And you know that why these kind of activities are permitted in India, because our constitution, our concept of constitution is not inclusiveness. Our positive secularism support the inclusiveness, and it never support exclusion of any citizens. So that is the one of the major reason why this kind of positive secularism never interfere on all matters of religion. These two incidents are also very important as far as our positive secularism of our Indian constitution is concerned. I just explained all these things because in order to explain the culture of Indian society is concerned, and which is inherently there in the Indian constitution. So, see, then we come to the hijab issue, and in this particular judgment. So, I explained what is our concept of positive secularism, and now I am going to explain what is actually the hijab issue, and what kind of rights are violated, and what was the opinion of Justice Gupta and Justice Julia. So there is no doubt about it that wearing a hijab is a matter of choice, and if it is a matter of choice religiously and according to law, it is a matter of choice, because according to Holy Quran, wearing hijab, because it is already mentioned in the judgment. When you read the Karnataka judgment, and when you read the judgment of the Honorable Supreme Court, you will understand. Because many pages are and pages of both the judgments where there are a lot of portions of Holy Quran and other religious law was interpreted. So if it is a matter of choice, because why it is a matter of choice? It is a matter of choice because Holy Quran neither mandatorily nor prohibit wearing of hijab, but it is a matter of choice. According to our constitution, wearing hijab is also a matter of choice of girls who profess Islam. Then why do you want to prohibit it? That is the most important question that is discussing in this particular case. This matter of choice do not violate any of the constitution provision. Is it violate any constitution provision? No, it does not violate any constitutional provision. In the judgment, in the Karnataka judgment, and also in the Supreme Court judgment, there is no violation of constitutional provision. The girls did not violate any of the provisions of the constitution, but their lot of rights are violated. So what are the rights of the girls are violated? For example, this right is denied to a child, and therefore it is a violation of the constitutional right of child. And these rights are violated to a girl. So there is a violation of constitutional right of girl and women. And there is lot of violation of right to education and right to development. And the right to development, as you know, that this is one of the most important right which is recognized by the United Nations Organization in the Universal Declaration of Human Rights and Convention on Civil and Political Rights, which is not appreciated by the court. And right to movement, because allowing to entering into schools, they are restricted to entering into a school because of these reasons. So it is a clear violation of restricting right to movement. and also right against discrimination, because in the judgment it is specifically mentioned the fact that a school is a potential public place. If it is a potentially public place, then if there is a discrimination on the basis of religion, then it is a violation of the constitutional provision, and also international convention, like International Convention on Prohibition of Discrimination Against Women and the Right of Child, United Nations Convention. So, and also the right to religious freedom, and denying the cultural and educational right guaranteed under Article 29, and also right to self-determination. It is also a very important right which is mentioned under the Universal Declaration of Human Rights. Because right to self, why it is violative of right to self-determination? Because in order to study, these girls want to go other states, other secular states like Kerala, Karnataka, Tamil Nadu. So they are denying their right to self-determination, because they want to study in Karnataka, because Karnataka is their native place. So, and also there is a violation of liberty and dignity of individuals, and also right to privacy, one of the most important right of a citizen. So, on the one hand, there is no violation on the part of these children, and as far as they are concerned, there are a lot of violations of the constitutional provision, not only constitutional provision, but also the human rights standards which are guaranteed by a child, guaranteed by a girl, to the international organization and other modern state, which was completely denied. When you analyze in judgment, you will understand it. So so this is actually the fact. So the question is, I already mentioned the fact that who is right? Justice Gupta is right, or Justice Dhulia is right? I like to say that Justice Dhulia considered Constitution as a book of control, book of discipline, book of limitation and restrictions. But Justice Dhulia considered this Constitution as a book of possibilities and a book of freedom, book of liberty and dignity of individual. That is the one of the major reason why I am only appreciating the decision taken by Gupta in his judgment, because of the simple reason that Constitution is essentially a book of compassion. Constitution is essentially a book of inclusiveness. Constitution is actually a book of freedom, and so that is what liberal democratic constitution look like. And liberal democratic constitution never look like control, discipline, regulations, restrictions, because as a nation, as a largest democratic country in the world, we are not moving from restriction to restriction, but we are moving from freedom to liberty. That is actually the idea which is specifically mentioned by the constitutional framers. That is the concept which is mentioned by the Supreme Court from its commencement in 1950. When you look into the judgments, we will understand. So that is one of the major reason why I'm saying that why Dhulia is right. I just mentioned. So this was his statement, which is mentioned in his para 23. Para 23. Why Dhulia used this constitution as a book of compassion, book of freedom, book of liberty? The first evidence is mentioned in section 23, where he mentioned a judgment. That judgment was Sri Mat case, which was decided by the Honorable Supreme Court 7-bench judge in 1953, where he mentioned about Mukherjee, and he mentioned this particular judgment, and this is available in section paragraph 23, where he mentioned that a religion undoubtedly has its basic in a system of belief and doctrines which are regarded by those who profess that religion as a conducive to their spiritual well-being. But it would not be correct to say that a religion is nothing else but a doctrine of belief. A religion may not only lay down a code of ethical rules for its followers to accept. It might prescribe rituals, observance, ceremonies, or modes of worship which are regarded as integral part of religion, and these form and observance might extend to even to the matters of food and dress. This was mentioned in 1953, and it was appreciated. Julia was appreciated this particular statement of Justice Mukherjee, and this was in the paragraph 37. Justice Julia mentioned about the Rama Janmabhoomi case, where he mentioned the fact that it is clearly mentioned the fact that the practice of religion, Islam, being not an exception, varies according to the culture and the societal context. That indeed it is the strength of our plural society. Culture assimilates a significant factor which shape the manner in which the religion is practiced. In a plural, diversified religious beliefs as they are practiced in India, culture assimilations cannot be construed as a future destructive of religion. On the contrary, this process strengthen and enforce the true character of the country, which has been able to preserve its unity by accommodating, tolerating, and respecting a diversity of religious faith and ideas. There can be no hesitation to rejecting any attempt to lead the court to interpret religious doctrine in an absolute and extreme form, question the faith of worshippers. Nothing would be a destructive of the values underlining Article of the Constitution. This is mentioned in paragraph 37. So Julia tried to appreciate the humanistic character of the Constitution by way of interpreting the previous judgment in Rama Janmabhoomi judgment, which was delivered by the Honorable Supreme Court in 2019. And also, it is a very important case that Julia appreciated. That is Bijoy Emmanuel versus State of Kerala. This case was a historical case and identical in facts and law with respect to the present case. The decision which this was delivered by two judge bench, that Chinnappa Reddy and Justice Dutt, and this decision, which is an essentially this I am quoting paragraph 39, where the decision which is an essentially importance in the case for our purposes is the decision given by this court in the case of Bijoy Emmanuel. It is necessary to refer to this case in some details, as in many opinions, this case is the guiding star, which will give us the path laid down by the well-established principles of our constitutional values, the path of understanding the tolerance, which we may also be called as a reasonable accommodation, as explained by some of the lawyers before this court. Karnataka High Court, all the same, choose not to rely on this seminal judgment for reason that Bijoy Emmanuel is not a best vehicle for drawing a proposition essentially founded on the freedom of consciences. But this statement is a vital, important statement of Justice Julia. This is very relevant also because this Bijoy Emmanuel case is a very historical case, which explain the heart and soul of Indian Constitution, especially Article 19 of Indian Constitution, because Article 19 of the Indian Constitution is actually the heart and soul of Indian democracy. But this is not correct. The decision of the Supreme Court is most relevant in the present case, both on fact as well as on law. That is mentioned under section paragraph 39. The different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional